Evidence. Relevance. Evidence must be logically and legally relevant. Logical. Federal rules of evidence. Evidence which tends to prove or disprove a material fact. California Evidence Code. Evidence which is relevant to a material fact. Legal. FRE 403, CEC 352. The court may exclude evidence if its probative value is substantially outweighed by the risk that it will waste time, create undue prejudice, confuse the issues, or mislead the jury. California Prop 8 Truth in Evidence. The Truth in Evidence Amendment makes all evidence admissible in a criminal case, even if it is objectionable under the CEC, California law, and criminal case only. Exceptions to Prop 8. I removed a number of the exceptions because they rarely came up. Defendant must open the door to their own character before prosecution can attack character. Court's power to exclude. The legal exclusion above, CEC 352, which is close to FRE Rule 403. Hearsay. Out-of-court statement offered for the truth of the matter asserted is inadmissible without an exception below. Non-hearsay. Otherwise, inadmissible evidence is admissible if not being used for the truth of the matter asserted, but for some other purpose such as verbal acts of independent legal significance, effect on the listener, prior inconsistent statements, PIS, or speaker's state of mind. Verbal acts of independent legal significance, non-hearsay. Words which have a legal effect and are offered to prove such, defamation, perjury. Effect on the listener, non-hearsay. Statement offered to show the person had notice of a fact or to dispute motive or intent. Prior inconsistent statements, PIS. Federal rules of evidence, non-hearsay, substantially admissible if under oath and available for cross-examination. California Evidence Code, exception, and any PIS may be offered for its truth even if not under oath. Speaker's state of mind. Then existing mental, emotional, or physical condition, and only for state of mind, not as to a statement of memory or belief. Admissions. Party admission, adoptive admission, vicarious admission, co-conspirator admission. Party opponent. Any statement made by a party may be used against them. FRE, non-hearsay, CEC, exception. Adoptive. Knowing content of statement, manifesting belief in the truth of it by words or actions. May be silent adoption by actions. Vicarious, by explicit authorization or employee agent within the course and scope of the relationship. California Evidence Code, only where negligence of the employee is the basis for liability. Co-conspirator, made in the course and scope of the conspiracy. Statement against interest, unavailable witness. A reasonable person in the same or similar situation would not have placed themselves of such risk of civil or criminal liability unless they believed the statement to be true. Federal rules of evidence, if offered to exculpate the accused, there must be corroborating evidence. California Evidence Code, also admissible if against the declarant's social interest, must be unavailable. Dying declaration, admissible where the statement is made while the declarant believes death was imminent and it concerns the cause or circumstances of their death. This never came up correctly. Federal rules of evidence, civil and criminal homicide only, death not required. California Evidence Code, must be dead, allows, quote, OJ exception for physical abuse. Present sense impression, PSI. Federal rules of evidence, exception. Admissible statement made while declarant was perceiving an event or immediately thereafter. California Evidence Code. Contemporaneous statement, explaining the declarant's own conduct while engaged in that conduct. Excited utterance. California Evidence Code, spontaneous statement. Admissible if made while the declarant was still under the stress of excitement caused by a startling event. Business records. Records kept in the course and scope of business activity made at or near the time of the matter described by a person with knowledge, and it is the regular practice to keep such records. Includes events, conditions, opinion, or diagnosis. California Evidence Code, events only, no opinions or diagnosis. Authentication. All non-testimonial evidence must be authenticated as proof the item is what the proponent claims it is. The line above is all we must know. The fact pattern will provide information about the details below to use as needed. Physical evidence may be authenticated through witness testimony or through unbroken chain of custody. Real evidence, distinctive characteristics or chain of custody. Demonstrative evidence, a fair representation. Writings and recordings, admissions, eyewitness, voice, handwriting, etc. Self-authenticating documents, certified copies of public records, official publications, newspapers, and periodicals. Ancient documents, Federal Rules of Evidence, 20 years old. California Evidence Code, 30 years old. Best evidence rule, an original copy of a document is superior evidence. Secondary evidence, such as a copy or facsimile, will not be admissible if an original document exists and can be obtained. California Secondary Evidence Rule. This is California's idea of the best evidence rule. The content of a writing may be proved by otherwise admissible secondary evidence. Authentication above applies. Court shall exclude if a genuine dispute exists concerning material terms of the writing and justice requires the exclusion or admission of the secondary evidence would be unfair. Witness testimony. Competency to testify. A witness who has personal knowledge of the matter they will testify about. Lay. Admissible if rationally based on the witness's perceptions and is helpful to the finder of fact. Federal Rules of Evidence may not be based on scientific or specialized knowledge. Expert. Admissible if the expert has the qualified education, training, and experience. Their opinion has been reached with a reasonable degree of certainty supported by reliable principles and methods, and their specialized knowledge is helpful to the finder of fact. This incorporates the Federal Rules of Evidence Dubert Kumho and California's Kelly Fry. Presentation of evidence, form objection. Facts not in evidence. Question assumes facts which are not yet entered into evidence. Leading questions, direct examination. Leading questions suggest an answer. They are not generally allowed on direct, however may be used to develop preliminary matters for youthful or forgetful witnesses, hostile witnesses, or for witnesses under the control of an adverse party. Cross-examination can ask leading questions. Refreshed recollection. Present recollection refreshed. After witness is shown an item, they recall the facts. Inadmissible evidence may be used. Other party may inspect and introduce pertinent portions into evidence. Offers to pay medical expenses not admissible to prove liability. Federal Rules of Evidence, collateral admissions of fact made during an offer to pay medical expenses are admissible, but not under this California Evidence Code. Testimony against spouse. Except as otherwise provided by statute, a married person has a privilege not to testify against their spouse in any proceeding. California Evidence Code 970. Character. Generally, evidence of a person's character is not admissible to show propensity, acting in conformity. However, character evidence is generally admissible for any non-propensity purpose, such as when character is the ultimate issue in the case or for impeachment. Character evidence, ROS, by reputation, opinion, and specific prior acts. Reputation, opinion, specific acts, prior acts. Federal Rules of Evidence, R&O, no S. California Evidence Code, ROS in criminal, no S in civil. Reputation in the community, Federal Rules and Evidence and California Evidence Code, OK. Opinion regarding a witness's opinion of the person, Federal Rules of Evidence, California Evidence Code, OK. Specific acts, also called prior acts, only allowed by California Evidence Code and only for criminal cases. Acts engaged in by the person in question which a witness testifies to. Prior inconsistent statements, PIS. Federal Rules of Evidence, non-hearsay. Substantially admissible if under oath and available for cross-examination. California Evidence Code, exception. Any PIS may be offered for its truth even if not under oath. Bias and personal interest. Obvious, use the fact pattern for specifics. Impeaching with criminal conviction, prior bad acts. Must have been convicted. False statement. Federal Rules of Evidence, admissible unless over 10 years old. Felony. Federal Rules of Evidence. If defendant, only if probative value outweighs prejudicial effect. Other witness. Unless prejudicial effect substantially outweighs probative value. This one definition is the opposite order of every other time we see it. It is more narrow. California Evidence Code. Admissible if not expunged, and felony involves moral turpitude. Misdemeanor. Federal Rules of Evidence. Not admissible to impeach. California Evidence Code. Civil, not admissible. criminal only for moral turpitude. Old convictions over 10 years old. No, unless probative value substantially outweighs prejudicial effect. Sensory deficiency. Kind of obvious, like in My Cousin Vinny, witness has thick glasses, hearing aid, etc. Rehabilitating impeached witnesses. Must meet the attack, can show the witness's good character, and prior consistent statements, PCS, may be used to rebut. Attorney-client privilege. Protects confidential communications between attorney and client for legal representation. California. This privilege does not survive the client once the settler closes out the client's estate. Attorney work product. Federal Rules of Evidence protects all materials prepared by an attorney or their agent in anticipation of or during litigation unless opposing counsel can show a substantial need for the materials and the information cannot be obtained without undue hardship. California Evidence Code only for materials prepared by the attorney in anticipation of litigation. Absolute privilege. Protection for an attorney's mental impression, notes, or opinions. Qualified privilege. Other materials prepared in anticipation of litigation are deemed as qualified work product and may be discoverable by showing a substantial need for the materials, and the information cannot be obtained without undue hardship.